Okay, thank you everyone for joining us on Financial Wellness Part 2, Estate Trust Retirement Planning for Families with Disabilities on today, Wednesday, September 20th at 6:30 p.m. We have Joanna from Empire, Randy Steer from the Law Office of Randy Hope Steer, and Adam Earl from National Care Advisors. Our disclaimer at the ARC. The ARC of Lehigh, Northampton County's Advocacy Department does not employ lawyers nor provide legal advice. This training or any others provided by the ARC Advocacy Department does not constitute or imply the endorsement or recommendation or favoring of the providing parties or any employees or contractors acting on its behalf. This webinar is being provided for educational and informative purposes only. Thank you for letting me share that. And with that, it is my pleasure to introduce our guest presenters, Joanna, Randy, and Adam. Thank you, and the Zoom is yours.
Awesome. Well, thank you for having us. I really appreciate the opportunity to speak to your audience because this is definitely a topic that is not often discussed or presented anywhere else. And I can tell you that the majority of the people that I sit down with on a daily basis say, like, who's really educating on these topics? Because this is the first time I'm hearing this, and it kind of, makes me a little sad. And then I say, well, at least we're doing what we can to get out there and do outreach and make sure that we do educate families so they don't make the mistakes that we commonly see. So thank you first and foremost. I am a financial advisor and special needs planner. I am the co-founder of Empowered Financial Strategies, and my specialization is working with families who are caring for a loved one with special needs. And as many of you know, this type of planning is unique. It's not cookie cutter because, we're not only planning for your lifetime, we're planning for 2 lifetimes of income. And we need to take into account government benefits, special needs law, and care management. And I firsthand have navigated the disability world, first as a sibling to 2 sisters who had special needs, and now myself as a caregiver. So I am sitting on the same side of the table as many of you are, navigating this complex and overwhelming world. And honestly, I understand that many of you are putting out fires every day. So we really try to meet our families where they're at, have patience, and take it as a step-by-step process. So we're not adding more overwhelm to your world. We do spend a lot of time on education, which I think is critical, so our families understand, so that they can make more empowered financial decisions. My business partner, Carolyn Humphrey, she specializes in designing our retirement income strategies. And I always equate it to, if you think of, because most people think, retirement planning in the traditional sense, but the game has changed and we need to change our game. And so retirement income is really like your if for any hikers out there in the audience, picture yourself hiking up Mount Everest. A hiker cannot just focus on going up the mountain, right? In order to be successful, you have to be well equipped with all the tools to get down that mountain. So what Carolyn really focuses on is making sure that our clients, no matter what happens, have a seamless plan to get through retirement. And what I feel like sets us apart, I'm going to toot our own horn here, is really our dynamic partnership, combining our 2 specializations into one comprehensive and meaningful plan for our clients. And again, I just want to say thank you for having us.
Sure. I'll hop in. I'm Randy Hope Steen. I'm a tax and estate planning attorney with a special focus in special needs planning. I've been practicing law for 30 years, and everything begins and ends with taxes. And if I'm the first one to tell you that, I apologize. I always say that, but they get us coming and going. So planning is designed to maximize benefits to your kids and minimize taxes, because that's where we start. Okay. And then everything else is designed around making sure that benefits are handled appropriately and our other kids are taken care of, and we are preserving wealth, but looking towards everything with tax planning as well. I am also the parent of a 16-year-old daughter who has rare disabilities, not rare disabilities. I feel like she's got everything, to be honest with you. It's quite a conglomeration of things, but I sit in your seat. My paralegals have children with special needs as well. My background is that I started in a small boutique tax and estate planning firm down in Philly. And then I was in-house counsel for PNC Bank, and I sat as a corporate fiduciary. And then I was the director of estate and business planning for Equitable Life for a number of years at Carbarth, which is sort of the local name for Equitable Life. And that's when my daughter was born, who obviously was diagnosed at 7 months old with special needs. And I stayed for a while. And then when she was 3, and as we all know, transitioning from early intervention to the intermediate unit, and we were trying to figure out where she was going to be, I dropped down to needing to spend a little bit more time with her and figuring that out. And that's when I left the corporate world and hung up my own shingle and decided to focus more in depth on the special needs planning, because part of my job as in-house counsel and as corporate counsel for PNC Bank was looking at all lawyers' documents everywhere across all the counties and reviewing them. And I saw a lot of really bad trusts out there. And I saw a lot of wills and documents done by lawyers who are not tax lawyers, which was always interesting to me, since we get taxed when we die. I couldn't quite figure that one out. And 25 years later or 30 years later, I still haven't figured that one out, but saw a lot of bad stuff going on. So that's always been the focus of my practice since. We've never looked back. That's what we do day in, day out. I am in your shoes, and we do it at a very, very high level. It is not run like a typical law firm. Our first meetings are complimentary. I recognize that you do not want to spend your time talking about death and taxes, but death and taxes we do talk about. So the first meeting's complimentary, because I know I have to get you in the door, because this stuff is important. I know once I get you, I'm going to have you, and we're going to get you taken care of and get your kids taken care of. But I got to get you in the door. Okay. But we offer complimentary annual review meetings, which most lawyers do not do. Why? Because our kids' circumstances change constantly. Not only does the tax law change every year, but our kids and our family circumstances change constantly. Sometimes the people in our lives who we think are going to be good people change. So we constantly have to be on top of it. And the phases of our lives change, and the people who we think are going to be trustees change, and our health changes. So we're looking at it. We age together. We're looking at different situations together. This is why we have to be on top of these things. It is a different kind of planning. With that, I'll leave you, and I'm going to pass it over to Adam to introduce himself.
Great. Thanks, Randy. My name is Adam Earl. I'm the president of National Care Advisors. National Care Advisors has been in business for the last 15 years and is specifically dedicated to helping individuals with complex care needs and their families. We work with clients all across the country. We have a team of over 40 professionals, nurses, education consultants, and other professional staff that work with over 700 clients a month to do a number of different things, but primarily helping families to plan for the future of their loved one that has complex care needs, and then helping them to implement those care plans. And so we work with clients to help really understand their vision for care and quality of life, and how that vision may change over their lifetime. And as parents and caregivers come in and out of their lives, how to best prepare for that vision for their future. And then how to help implement that care plan to ensure that the resources and the services that are available to them are made available. So I've been with the company for a little over 8 years now, and a number of different roles, but have been in healthcare my entire career. And really excited to share a little bit more about our experience with you guys today, and chat with Joanna and Randy.
Well, thank you, the three of you. My goodness, we're going to have a lot of good knowledge tonight. So I'll start with Randy, if that's okay. I have a question for Randy. We'll start off. So Randy, if you could tell us, what are the important estate planning documents parents and adult children should have? And the second part to that is, why does everyone need a will?
Okay, so we will start with sort of the first document that people need at 18, because that's really the document children need at 18, how the legal scary age when our kids become emancipated. So 18, our kids are considered adults, whether we think they're adults or not. This goes for neurotypical kids too, by the way, they're animals at 18, but this is the reality. So our children are considered emancipated at 18. That means we cannot make healthcare decisions for them. We cannot access their medical records. We can't make financial decisions for them. So we hit our first bump in the road where we have to decide, are we going to have them or attempt to have them sign powers of attorney for medical reasons and healthcare reasons? Do we have to consider a guardianship, or are we going to kind of roll the dice and go with this healthcare representative law that is in place in Pennsylvania, which probably most people on this call have never heard of? Okay, so powers of attorney are what everybody on this call should have. And every neurotypical kid who turns 18 should have a healthcare power of attorney if they're going away to college. This is because of the HIPAA laws of medical privacy. Even if you're married, you are not supposed to be able to make medical decisions for your spouse without a healthcare power of attorney. This is widely violated for spouses, and you've probably seen this. If your spouse is in an accident or needs emergency treatment, probably a doctor will talk to you. If you and your spouse are in a car accident together, we have a problem. We are then in the realm of emergency guardianships if we don't have proper healthcare powers of attorney appointing alternatives to this. Same reason, this is why we need them. This is why our kids need them at 18, to give us permission to assist them. Powers of attorney don't take away any rights. They allow us assistance. Financial powers of attorney, same idea. Everybody on this call needs those, even if you think you don't. If you own everything like this with your spouse, what I call I love you, old school I love you, we own everything together, you actually don't. You might think you do, but you don't, because certain asset classes are not owned that way. So think IRAs, 401ks, pensions, most life insurance, annuities. Most of those asset classes are owned individually. Being a beneficiary of something does not make you an owner and does not give you entitlement to act on those accounts. So if somebody becomes disabled, those accounts get frozen. And where are we? We are in court again if we don't have financial powers of attorney. So everybody needs these things. Why do I mention this? This is important because it is easier to get your children to be willing and able to sign these if we say everybody has these. We have these, you need these too. Okay, so powers of attorney allow us help. Everybody should have them. And if we can have your kids sign these at 18, this is the most economical, cost-efficient way to do things. It allows us to help. It does not strip them of any rights, any dignity. It allows us to get in there and help. And judges want this. They want the least restrictive environment. Okay. Capacity to sign is what it hinges on. This is where it gets sticky. What is capacity to sign? Okay. I never want to insult anybody, but understand capacity to sign is not understanding all the legal words in the document. You are not going to understand all the legal words in my document. You are not supposed to. Lawyers make their money by making things confusing and using words that look like English, but are not really English. Okay. You're not supposed to. That is not capacity. Capacity is understanding the nature and spirit of what the document does as it's explained to you. So if your children can understand, is it okay if mom and dad help you with your doctors? We are good to go on a healthcare power of attorney. If they understand, is it okay if mom and dad help you with money? We are good to go. And signing does not mean cursive. If they can do cursive, great. If it's print, great. If it's hand over hand, we can accept that in Pennsylvania. If it's signing by mark, we have special notaries in Pennsylvania that we can do that. If it's thumbprint, we have special notaries for that too. So signing means many, many things in Pennsylvania. Powers of attorney are optimal. What if we have a situation where parents really feel there is no capacity, or there's a clear-cut situation where there's no capacity? We have a child with a 23 IQ or something like that. We may have to go the guardianship route. Guardianship is plenary guardianship is what most parents would come to me for, which is full guardianship over the person person's body and their money. So we are saying they have no capacity at all to understand, and it strips the person of all rights, including the right to sign a job application. So understand that, okay? All rights, no right to sign a job application. Judges do not like guardianships, not now. Judges, the pendulum has swung completely away from it, okay? Your child will be appointed an attorney to represent them. In Montgomery County, actually, the Disability Law Rights Project was awarded that contract, and they are representing people. Now, if it is a clear-cut case, and your definition of clear-cut may be different than a judge's definition of clear-cut, that's not a problem. Because if somebody is so severely incapacitated, we are not going to have a problem getting them a guardianship. But it is much more expensive than powers of attorney. And we are not going to send somebody down that path unless we think we're going to win at this stage of the game, because judges are very much against it. It does take away someone's rights. It does not solve behavioral issues like impulse control issues, somebody being promiscuous, somebody being an elopement risk. It will solve it once, twice, 3 times, 5 times, maybe 10 times, but there will come a point where a police officer will stop bringing somebody home. Telling you the truth, whether you want to hear it or not. If they are gamey enough to escape, elope, get themselves transported somewhere, do those things, cops are going to stop coming after a certain point. So it's not going to keep somebody safe from bad choices, just like anybody else, or bad behaviors, or bad drug use, or hanging with a bad crowd. A couple of times they'll be brought home, but it's not going to stop that. Unfortunately, it's a very hard fact of reality. Okay, only 2 people can be on a guardianship at one time in Pennsylvania. Seen maybe twice in 30 years where a judge has allowed 3 people on. So what we're talking about in reality most times is that they will be, when you're gone, we're back in court for another guardianship. Okay, what guardianship, so it's a little limited, where in powers of attorney, we can have a really robust line of succession. We can say if mom and dad can't do it, then Uncle Joe can do it. If he can't do it, then my brother can do it. We can go make those powers of attorney go real far. Okay, and then the guardianship, it can be very effective in one realm. It can be very, very effective if we have somebody that truly can't make any medical decisions. Great, then it's law. Somebody who is resisting life-saving medical treatment, we may need to step in and do an emergency guardianship or handle guardianship on that level, because we just may have to, okay, do those things on that. And it can be definitive, where if we have somebody who waffles with their behavior, who really doesn't have capacity, who can be a risk to themselves or others, then maybe it's appropriate. But we really, really have to look at it. Anybody borderline right now, borderline IQ, we are not getting guardianships on those cases. And it's not going to keep your child safe. The other alternative we have is a healthcare representative. This law sounds great in theory if someone doesn't rise to the level of guardianship, but we are on the fence as to whether they have capacity to sign a power of attorney. There's this law in Pennsylvania that says if you're the parents, you can say, I am their healthcare representative, and you should be able to make decisions for them. The problem with the healthcare representative law is most people don't know about it. Most doctors and hospitals don't know about it. And they're going to ask you if you have power of attorney or guardianship. So right now, it doesn't do us a whole lot of good. Maybe this will evolve as things go on with the pendulum swinging on guardianship. But right this minute, it's the law of the land seems to be powers of attorney versus guardianship. So right now, when our kids are 18, we have to get these documents in place or make a decision one way or another what we are going for. Other documents that we need, and I'll get more into it later, of course, we need a special needs trust, because our kids at 18 to get benefits cannot have more than $2,000 in their own name. So we need a trust to house monies that we want to leave them so they can have the best quality of life. And we all need wills. We need wills if we care how our money passes, because if we don't have wills, the state has a will for us and it does not say what you think it says. Okay, it will allow you to leave your spouse a very small amount of money, the first $30,000, and then they split the rest with your children. Not what you want unless you really dislike your spouse. And that means your children will get the money outright at 18. Our special needs kids cannot get their money outright at 18. And our neurotypical kids cannot get their money outright at 18. It would be gone like this. And they matter too. We want to protect them. We want to protect them from potential bad spouses. We want to protect them from creditors, from bad decisions and other things. There's ways that we tie things up. And also wills are the only place for your children under 18 that we can name physical guardians. Very important that you take the time to name physical guardians of who would your children live with if something happens to you. Okay, very, very important. Also, wills are where we set up tax savings in our wills, and we handle certain very important things. If certain benefits flow into our wills, how are we going to handle that to maximize tax benefits to our children and things? Wills are critically important. And with that, I will stop so somebody else can get a chance.
Thank you, Randy. So Joanna, so what are some common planning mistakes and how do you help clients avoid them?
Thanks, Deb. That's a really great question. So one of the first things that I see when I'm working with clients is they say, well, you know what, I'm just going to disinherit, my son or daughter because they can't have more than $2,000 in their name. So I am going to not leave them any money. Well, guess what? Now, what do? They have no money. And they think that because they left it to someone, maybe there's other siblings, that it's going to actually get there. I share this story because I think it's really impactful. So as I mentioned, I had, and I say had because they're both now passed, two sisters with disabilities, one with Down syndrome and one with severe mental health issues and addiction. My parents' plan, because nobody was talking to them, was that they were going to leave their assets 50-50 to my one sister who had mental health issues and me, and that we would take care of my sister, right? If anything should happen to them. Well, let me tell you why that plan wouldn't have worked. First, as I mentioned, my one sister with mental health issues had really bad spending habits, and money grew on trees for her. So any money that she had, she would spend. Secondly, later on down the road, she had addiction. So any money that she had in her hands was unfortunately going to drugs. Another thing that happened in our family's life and to be considered is divorce. So I went through my own divorce, and had that plan actually come to fruition, 50% of those assets would have been lost in my divorce. So as you can see, I think parents' intentions are in the right place, right? But
Yeah.
These are the mistakes we see. And so what we do is we want to make sure, as Randy mentioned, that the assets land in the right place, which is really the special needs trust. So we don't want to disinherit them because they do need probably more money than anybody would need. And leaving assets behind to well-intentioned family members also doesn't mean that the money's going to get to them. Now, the other mistake we see all the time is that people have their son or daughter listed as a beneficiary directly on life insurance contracts, on as contingent beneficiaries on IRAs and 401ks. Well, why is that important? Well, leaving assets to someone who's receiving these critical benefits can kick them off those benefits. Okay, so we don't want that to happen, or we have to be reactive in those certain circumstances and create a first party special needs trust, which Randy's going to talk about later. So leaving assets directly to someone is a big no-no. No plan at all. Procrastination. And boy, this is an easy one, right? I mean, who has all the time in the day to get all of this stuff done? I certainly know that it's daunting to find the time to plan, but we must, because what can happen if something happens yesterday, we can't go back. So we want to make sure that we're putting our best foot forward and layering it. This is not going to all happen overnight, but taking pieces of the planning puzzle, I say, whether it's week by week or month by month, so that your child does have a plan. And so the state of Pennsylvania is not coming in and designing a plan that you probably wish wouldn't have happened is really critical. So I would encourage all the families that are on here tonight. You're here for a reason. You're here to gain more information. And I encourage you to make that next phone call or that next email, because this will impact the future care and quality of life of your loved one if there's no plan in place. The other thing I see is that people don't update their beneficiaries. I was just on a call earlier today, and like I said, their child was named outright on a life insurance contract. Just because the will says all of my assets are going to a special needs trust doesn't mean that these contracts that are legally binding, that's what's going to happen. Because life insurance, annuities, 401ks, 403bs, IRAs, all of those things are a contract. And when you pass, whoever's listed on there, well, that's where the asset's going. So we want to make sure that our those contracts like life insurance and like your retirement accounts, your plan is coinciding with the work that Randy would do in the estate documents. So we're always updating and checking beneficiaries. And lastly, it's working with professionals who are really specialized in this area is really, really critical. I'm sure Randy can attest to this. How many trusts have you seen with Medicaid, third-party special needs trusts with Medicaid payback provisions? On a call earlier about, they had all these different expenses for a wheelchair accessible van, and they had this expense and this expense. And I said, okay, did you work with your accountant? I know that there's exemptions, deductions, and tax credits. No, I had no idea. Because the CPAs out there are not asking these really critical questions. Do you have a dependent with a disability? So, and even down to the financial advisors, that's great. You're doing general planning, retirement planning, but if you're not well versed in government benefits, and not only that, but other resources your families can take advantage of, well, you're doing your clients a disservice. So I always encourage people, when you're working with professionals and you're designing your plan, you want to make sure that they're specialized in this area of planning. So we work with them to avoid these common mistakes that we see.
Very good. That was very helpful. So Adam, it is your turn. So I understand that National Care Advisors build out a quality life plan. Can you tell us more about what that looks like and the impact it has with families that you work with?
Yeah, absolutely. So it kind of dovetails into what Randy and Joanna were talking about. We certainly see families face the challenge of wanting to plan but not knowing where to get started, or starting the planning process and kind of hitting a roadblock. And one of the major roadblocks that we've seen families run into is, I know I need to create these documents. I know I need to plan financially, but how much money do I need to set aside? What does my plan look like? What is, on a practical day-to-day basis, what does my vision or my plan for my loved one with a disability look like in the real world? And so as we were working with other professionals and families through this, we have, kind of developed a process or a plan, a methodology for really helping families to map out that vision, to really work through the specific details of what it's going to look like on a daily, monthly, yearly basis for their loved one. When we think about this, we think about this holistically, not just for the individual with the disability, but how is this going to impact everyone else in their life, their caregivers today, their successor caregivers, their siblings, their aunts, their uncles, other members of their community that are providing support to them. And so that's why we call it a quality of life plan, because it's really about quality of life for the individual, but also quality of life for the family as well. The kind of nuts and bolts of the quality of life plan are really kind of simple on its face, but we help clients through the process of first really kind of mapping out what their vision looks like for the future. And I think sometimes when we work with families, they have a hard time having the mental space to do that, right? You have all sorts of things going on in your life. You're just worrying about the day-to-day, getting your kids to school and making sure that they're safe and that their appointments are met. So taking that time to really kind of take a step above everything and kind of plan for the future can be a challenge. And so we work with families to guide them through that vision planning process to say, okay, where's my son or daughter going to live in 5 years, in 10 years, in 20 years? How does that impact my and my spouse's plan? We want to retire, we want to travel, we want to do other things, we want to be there for our other kids. How does that impact, that future that I have envisioned for myself and for my family? And so by mapping out that vision, we kind of walk through all the different aspects of life: transportation, housing, caregivers, medical, doctors and therapies, medications, everything that is really important to the care and quality of life of that individual, and write it down really, and get that out of your head, because a lot of folks have thought about this, but they haven't put it down on paper in an organized way. Then we start to kind of take that vision and say, okay, what's it going to cost from a practical basis? Joanna talked about planning financially and making sure that you have the resources available, and certainly, working with Randy to create a special needs trust. But how much money do I need to put in a special needs trust? And so that's really the kind of next step of that conversation, is to cost all of this out and say, okay, we have this vision laid out. What's it going to cost for my son or daughter to live in an independent living facility? What's it going to cost for them to have a caregiver 8 hours of the day to make sure that they're safe and secure and get those tasks done? And so we walk through those cost models. And then build in public benefits. So we want to make sure we're preserving access to those public benefits. Public benefits can pay for and support a lot of those different items in that quality of life plan. But how does that intermix with your vision, and what are you going to take advantage of, and what maybe would you not take advantage of? And so what we come down to, and that is a cost model that you can then use to plan out your financial future for the individual with a disability. So that's really kind of the crux of it, is helping families through defining that vision, understanding what that future may look like and what their options are, and what ultimately it's going to cost. It does really two kind of purposes, or serves kind of two purposes. One is just peace of mind and organization. A lot of parents, this is what keeps them up at night, is what does the future look like? What's going to happen to my loved one, even if I live to be 100? What does that look like? God forbid if something happens to me tomorrow. And so by writing all of this down and developing a plan, it kind of solves both of those problems and says, if something happens to me tomorrow, I know my successor caregivers for my loved one have a plan, and that it's realizable, and that we have a financial strategy built around that to make it possible. But also, if I live to be 100 and enjoy life alongside my son or daughter with a disability, I know I'm prepared for that as well, and I have a plan and a financial strategy to make that vision a reality. And so that kind of peace of mind and organization is really helpful. And then certainly kind of building that into your financial plan to ensure that special needs trust that you set up has enough funding in it to make your vision a reality, and your son or daughter doesn't end up either short or having too many assets, and that you've unnecessarily disinherited other members of your family, other siblings, because you were afraid that you wouldn't have enough to cover the individual with a disability's care needs. So that's really what we try to help with the quality of life plan, to round out the planning process in collaboration with great attorneys like Randy and financial advisors like Joanna.
Thanks, Adam. That's great information. And I heard both you and Joanna talked about special needs trust. So Randy, can you tell us the difference between a first party and a third party special needs trust? And can you explain why it's so important to have a special needs trust?
Sure. So a third party special needs trust is the most common trust that you would come see me for. This is what we call, or I like to call, proactive planning. So that is when parents, grandparents, it could even be a sibling, come to see me and they want to create a trust for their loved one where they can gift assets, or other people in the family can gift assets to them during life or upon death, to make sure that the child family member has the best quality of life now and in the future. And then when that person passes, they can leave that money to other children, other family members, charity, whoever they want. And I think of it as an all in the family trust. It stays in the family. The state has no right to that trust. There's no payback to that trust, because it is funded with other people's money other than the disabled person. So parents, grandparents, siblings, friends, whoever. Okay. So it's private money. A first party special needs trust is exactly what it sounds like. First party means funded with the disabled person's own money. That's what it means. First party. Okay. We don't put anybody else's money into these trusts. So this is what I think of as reactive planning, because these are what you hear called payback trusts. So these we form when somebody has money in their own name that we really don't want in their own name. It's happened when they're either over 18 or they had a ton of money in their name and we need to qualify them for benefits, or some well-meaning person leaves them money after 18 when they're already qualified for benefits, like grandma leaves them an inheritance into their own name. We have this great trust, nobody listens to us, they get an inheritance, or they're in a car accident and they're the recipient of a lawsuit settlement. This happens sometimes, and we need to form a first party trust because we don't want them knocked out of benefits, okay? What a first party trust allows is it allows us to move significant excess money into the trust. Our child can continue to receive benefits, but the catch is the day that they pass away, the state gets to come in with a bill and get paid back for all the services that they have rendered. Now, if there is zero left in the trust, there is nothing left to get paid back. Okay, if there is money left in the trust after the state gets paid back, then it can go to other beneficiaries that we name. But for most of us, there is no money left in that trust after there's a payback. Or in my world, I like to make sure there's no money left in the trust to be paid back. That becomes our first line of defense, that first party trust, because we know it's not going to go to our other family members. So that's the first money we use. So first party is reactive. Third party is proactive. The other uses, and everybody really needs to listen to this one. And if you have friends that this applies to, keep this in mind. Child support for special needs children is forever. It does not stop at age 18. If this upsets anybody, I'm not going to apologize, but it's the truth if you don't know this. After 18, it can't be called child support anymore. If it is, it's counted against them as far as receiving benefits. They will not receive SSI. They will be disqualified because it is dollar for dollar income in kind. So in cases of friendly divorce, and we actually have them, there are people who actually get divorced and get along, we can lift the child support order and we can have money go into the third party trust, proactive planning, and it can be nice. Lots of times it's not nice, and we have to keep a child support order in place because we don't trust the person, or revise a child support order to address, more adult needs. And the first party trust is formed, and we have a judge direct the child support into the first party trust so it doesn't negatively affect this SSI. We get the SSI and we get the child support. Okay, very, very important. Okay, very important. Divorce lawyers do not necessarily know this and know the law when it comes to SSI. This has to trigger in everybody's brains. Child support at 18 is going to disqualify your child. That doesn't mean you shouldn't seek it, have it. It just has to be managed, okay? So first party, third party, that's the difference between the two. Why is a special needs trust so important? To qualify for benefits at 18, there's a $2,000 resource limit. Child has to be impoverished. This is the law. To get these benefits, they have to be impoverished. Your income no longer counts once they are 18. It is their income. They can't have more. What they would get today in SSI is $914 a month. That is supposed to cover, or is it not? It's $941. Supposed to cover room, board, utilities. In no world can you live on that. Okay. So we as parents, we are supplementing them while we are here. We are assisting, we are helping them. The job of a good special needs trust is to be the financial parent when you are no longer here. When you are gone, it steps in and it is doing that. It is everything that you are doing to supplement them, that special needs trust is doing to supplement them when you are not here. So benefits first, those are the rules of the game. Benefits first, and the special needs trust, as long as the wording is correct, is supposed to step in and make sure they have everything they need to keep up with their accustomed standard of living in your trustee's discretion. That's the name of the game for a special needs trust. It is supposed to be based on their accustomed standard of living, when all the benefits they are getting, all the services they are getting is not enough to do that. Okay. That's what it is at play to do, to be the financial parent when you are no longer here. And we can use it for anything from resources to therapies to vacations to building a gaming room, which we've done. You know, the trust can buy a house regardless of what you've ever heard. Trust can buy a house and not negatively affect benefits. You just have to be smart enough to have the child use their benefits to pay rent to the special needs trust. You just have to know what you are doing.
Okay, thank you, Randy. So Joanna, Randy had mentioned benefits. So how do you work with clients to protect and maximize government benefits?
Oh, the world of benefits. Let's put our seatbelts on. Well, as Randy mentioned, it's you are correct, Randy. 914. I know it's been a long day. 914 a month is supposed to cover everything. So the reality is, it's not going to cover everything, and it's certainly not going to give your son or daughter future care and quality of life. So we need to think about, you know, where are the where's the other income going to come from? But that being said, we want to obtain the benefits, we want to maintain the benefits, and we want to maximize the government benefits. And that's all a part of our planning. So our goal is to really leverage what we can from the government. And if anyone is currently in the process of obtaining benefits, I'm sure you're already overwhelmed. So that we can maximize what the family can do from a self-funded perspective, because we know that care is certainly not cheap. But the first thing we need to really do is identify what benefit the individual is trying to obtain or are on, which can often be confused. I can't even tell you how many times people say they're on one benefit when they're really on another. If they are, not on benefits, we're going to be working with the family to get them on benefits. We don't do that work ourselves, but we kind of highlight the important things to document in those documents. And if it's kind of a gray area, I always say there's attorneys who can really help them obtain these benefits, and there's no out-of-pocket cost to do that. It's based on, and I'm going to forget the word, contingency, or Randy would probably know the better term, legal term for it. But to meet with a disability attorney to obtain SSI is no upfront out-of-pocket cost. So there are two different programs with different rules and different staff administering these programs. There's SSI, SSDI, often confused. Medicare and Medicaid, often confused. So the one way, if you want to find out what you have, is to request what's called a benefit planning query. For people that are age 19 to 65, it's called BPQY form SSA 2459. And if you request that, you'll see exactly what your individuals are on. To be able to receive either benefit, your loved one has to qualify. And just because they have a disability or a medical diagnosis does not mean that they're going to qualify for disability income. Children under the age of 18, they have to have a medically determinable physical or mental impairment that has limitations, severe limitations, and is expected to last for more than 12 months or result in death. And adults over the 18, and this is really where I see like our clients, most of our clients are not seeking SSI when we're working with them until their children are 18 and up, because again, as Randy mentioned, it's to receive SSI, you need to financially qualify for it first. So for most of, and not all, the families that we're working with, because of their income and assets, they're not going to qualify for SSI based on the child, because the parents' finances are counted. But post 18, okay, a lot of our clients are coming to us and their children are right on the cusp and they're applying for SSI. That child, the definition for Social Security, that they're disabled, again, because it's all different terms. Just because your child has autism doesn't mean that they're going to get benefits, is the inability to engage in substantial gainful activity often used. There's an acronym, you might have heard SGA. Social Security loves acronyms, and so does the world of disability. So if you hear that, that means that basically your son or daughter cannot work and provide for themselves on a full-time basis, and that their condition or medical impairment or mental impairment is expected to last for more than 12 months. Okay, so again, just because your son or daughter has a disability, you have to prove to Social Security that they're not going to be able to have any substantial gainful activity. Now, SSI is a needs-based program. As I mentioned, you have to be eligible to receive it financially and medically. And SSDI is an entitlement program, which means that you're entitled to it because you're paying into the system. As I mentioned earlier, just to reiterate, the current maximum SSI is $914 a month for 2023. SSI is tied to Medicaid and waiver. So if you get $1 of SSI in the state of Pennsylvania, you automatically qualify for Medicaid. Some states are different. It's 2 separate applications, but in Pennsylvania, if you qualify for SSI. Now, some of my clients have children that are, 9, 10, 11, 12, and they're on Medicaid and not receiving SSI, and that can certainly happen as well. Medicaid we need for a lot of those health benefits. But in order to protect this benefit, right, we want to, like I said, we want to obtain, maintain, and protect and maximize. We need to keep wages under a certain amount. And right now in 2023, it's below $1,913 per month. And as Randy mentioned, we got to keep resources under $2,000. This limit has not changed in a very long time. It's a federal limit. I know that there's discussions now about raising that, but for today's purposes, it's $2,000. The list of what's non-countable assets, it's a much smaller list. So I always tell people, rule of thumb, don't save in your child's name or give out their Social Security number, because they can't have more than 2,000 in their name. And if it's the first time you're hearing this, it makes me sad, because, and when I was doing these presentations in person, I always ask people, is this the first time you're hearing it? And almost every single hand went up. And this is why we're here tonight. But if we want to maximize that benefit, we're going to charge our children room and board. And some people feel icky about doing that. And I say, well, if you don't, SSI is going to be cut by 1/3. Remember what Randy said, those in-kind supports. So we want to make sure that we're getting the full amount. Now, what you do with that room and board is part of our strategy, right? How can we kind of use those room and board dollars to eventually get back to your son or daughter in a meaningful way that's going to give them that future care and quality of life? Another thing that you can do for some of our individuals that are working, that are on SSI, we want to make sure that we write off any impairment related work expenses, so that if they are working and their SSI is being cut by a dollar amount, you are able to reduce that by writing off what's called impairment related work expenses, also known as IRWE or IRWE. Social Security disability, and I know I saw this and I want to make sure I address it in the question. Someone had a question about, like, what does my son or daughter get when I retire or when I pass? What is that amount? So we're going to talk about that right now. Social Security disability, for those receiving these benefits, it's an entitlement. So for any of you, I would highly encourage you to go on SSA.gov and log in and look at your own Social Security statement. If you're working and you have so many quarters, you're entitled to retirement benefits, but you're also entitled to disability benefits through the Social Security system. And so when we retire, our children are entitled to something called the DAC benefit. Now, the DAC benefit stands for Disabled Adult Child Benefit. And as long as their onset of disability occurred prior to the age of 22, okay, they are entitled to this benefit. And what does it mean for your son or daughter? Is that when you retire, they can collect, they would flip over to this benefit, and it's approximately 50% of the primary insurance amount, which is also really that if you look on the Social Security statement, you're going to see full retirement age, let's just say it's 67, right? And there's an amount there. So take 50% of that, and that's what you can count on. Of course, the more quarters you work, the higher it's going to be. And then we can also look at, okay, what potentially, if we're using an inflation factor of 1 or 2%, I like to be conservative with Social Security. What could that look like in the future? Now, if you delay, and I know this is one of the questions, if you delay your retirement to 70, that does not mean that your son or daughter is going to get a higher benefit. Okay, so when we are working with our clients, we're saying what strategy makes the most sense between, if there's a couple or single, for the most appropriate age to start benefits. If you were to become disabled, your child can also collect that 50% amount, and when you pass, it bumps up to 75% of that primary insurance amount. Okay, so I know that's a lot of stuff, and I don't put myself out there as a Social Security benefits expert, but I know enough because I'm working in this day in and day out. The one thing I want to mention is if your son or daughter is receiving SSDI through the DAC benefit, Social Security does not care about assets. Okay. If you have, if you go on Social Security disability and you have millions of dollars in your bank account, they don't care, right? Because it's an entitlement. What they do care about is income. Okay. So in 2023, if you are making more than $1,470 a month, they're going to say, wait a second here. I thought you were disabled and you have substantial gainful employment. Okay. So we have to be more in tune with how much someone is making when they're on Social Security disability. Social Security disability is tied to Medicare. So once our children qualify for SSDI through the DAC benefit, there's a 24-month waiting period, and then they can qualify for Medicare. And they can be, and I know that there's been a lot of miscommunication about this, they can be on all 4 benefits at the same time, essentially. They can be on SSI, Medicaid, SSDI, and Medicare. Now, most oftentimes, because that 50% amount of the primary insurance amount is more than $914, I often see people be able to collect the DAC benefit, 24 months later, qualify for Medicare, and also be on Medicaid. And we still need Medicaid because Medicaid is tied to waivers. If you are receiving certain waivers, you do have to be careful of assets. So again, it's a lot of moving parts when we're working with our clients to make sure that we are protecting these really critical benefits. I think I covered most of what I wanted to cover. I know it's a lot, and I hope I didn't make your head spin too much. But there's resources out there. You don't need to memorize this stuff. That is why there's professionals that do this every single day.
Very informative. Thank you for that. I do want to give a quick heads up. We have 30 more minutes, so we're going to go on to the next question and see how much we can get through. So the next question, Adam, for you was, what are the top challenges families face, and how do you work with them to overcome these obstacles?
Yeah, of course. Joanna actually just hit on the biggest one, as you can kind of imagine the complexity of benefits. Before I get to some of the top challenges, though, I just want to mention too that I mentioned a little bit about what our firm does, helping folks implement their care plans and help kind of realize the benefits and resources that are available to them. We do this both while parents are still living and helping their loved ones to provide care, and once they pass and kind of providing that support when they are no longer able to. One of the questions in the chat was, what happens when my special needs trust transitions to a professional trustee? Who's going to kind of take the mantle of me helping to make sure that all those plans that we put in place actually come into reality? And we work with special needs trustees all across the country, and there's others like us to help that. So there'll be a team of folks through that corporate trustee or professional trustee or family member trustee to help kind of make sure that plan becomes a reality. And really kind of making that plan a reality is about kind of overcoming these challenges that our loved ones face, and helping them to resolve the daily issues that come up and arise. Benefits is certainly a big one. As Joanna mentioned, it's complex. It's she told you all sorts of different things about Social Security and Medicaid and Medicare. But there's all sorts of other benefits that our kids can qualify for, both when they're young and when they're adults. There's waiver services, there's Department of Disability services, there's housing assistance, there's cash assistance, there's assistance for utilities, there's assistance for internet. There's all sorts of different assistance programs that our individuals with disabilities can qualify over their lifetime. And it's a lot. It's there's a lot out there, and it's confusing, and there are different rules for each program, and they're administered by all sorts of different agencies, and there's applications all over the place. And it makes sense that it kind of makes your head spin. And so that's one of the things that we help with all across the country is helping families navigate this benefits landscape. And we help folks with advocacy work to ensure that that the rules are being applied fairly, because some things that we'll find is that they have a case manager through Medicaid, but they're not necessarily receiving the benefit that they think they're entitled to, and it takes some advocacy and some pressure on those organizations to ensure that they're providing the resources that the individual is entitled to. We help with application support, making sure that you're filling out the application correctly, and that when you go through the interview process, that you're answering questions truthfully, but that also present your son or daughter in the best light possible to ensure that they are receiving the benefit. A challenge that parents face is that they go into disability determination interviews and they talk to the evaluator and tell them how great their son or daughter is, because it's naturally what we want to do as parents, is to talk about all the great things that our kids do. Unfortunately, when the evaluator is looking at that, they're thinking, oh, well, this individual is awesome. They can do all these things independently. They don't need help. And so they'll decrease your benefit because of that. And so, we work with parents to kind of frame that a little bit differently, to say, let's talk about our worst day when we're talking to benefits folks and we're asking for help and asking for support, so that they know that you need help, and that this individual really needs some support from the government to help them achieve their maximum quality of life possible. And so really that advocacy is a big part of what we do from a benefits standpoint. We also help families with school challenges. So it's kind of becoming a bigger topic of conversation for families, and for our staff in particular, is families butting heads with school districts and having challenges with IEPs and 504 plans, and receiving the support and services and resources that are needed to ensure that their kids receive the education that they deserve and that they're entitled to. Despite what anyone says, every child, regardless of their level of ability or disability, is entitled to a free education in the United States, a free public education. We run into clients, attorneys, financial advisors, trustees all the time that tell us, my client's son is too disabled to go to school. That's not true. That's in no way, shape, or form is that something that is something that anyone should say. But it does take some advocacy to ensure that that these individuals can go to school safely, that they have the transportation that they need, that they have accommodations, that they have the supplies and therapies and resources at school. And so we have a team of education consultants on staff that help with this advocacy work to ensure that the public school districts are playing their part and providing the resources that they need. And that extends beyond the public school as well. Most of our kids who have a disability can go to school up to age 21 or 22. But there are many of our clients who have a disability that have the opportunity to go to vocational school, or go to a 4-year college, or go to community college. And we want to support that journey as well. And there are many of these organizations have accommodations and resources available to help folks with disabilities achieve maximal education. And so helping them through that process and really understanding what they're capable of doing, and giving them the resources to do that. The last big challenge I'll mention really quickly is just finding caregivers. With COVID, one of the reasons why the school district challenge has been a big challenge is because of COVID. COVID also contributed to our caregiver shortage that was exacerbated by COVID. And so finding caregivers, whether it's respite caregivers or folks in the home full time, any combination of that, can be a time-consuming process to locate those folks, make sure that they're high quality, make sure that we're paying them at the right rate, and making sure that we can use benefits when possible to cover the costs of those caregivers, because they can be expensive. So we work with families and clients and their financial and legal advisors to really make sure that they have the right resources at the right time, and that they have the right skill levels to provide the best possible care to folks that need it. And so that's one of the other big challenges that we work with folks to overcome.
Thanks, Adam, for that. And yes, we as advocates know the difficulty parents have to deal with school districts on a daily basis. So, and myself myself as a parent and a grandmother now. So Randy, I have another question for you. If you could just quickly talk about what are common mistakes in drafting these trusts, and why is it important to work with someone who has a specialty in that area of planning?
Well, anytime, look, if you have a heart problem, you go to a heart surgeon, you don't go to a general practitioner. It is the same analogy. You want somebody who does this day in, day out, who lives it, who breathes it, because frankly, it's just too important. And laws are changing all the time. Things are changing all the time. And you just want to make sure that it is right. The most common mistake I see, and Joanna actually mentioned it, it is a super common mistake, is these third-party trusts that we talked about, these proactive, all in the family trusts, have no payback requirement to the state at all. They stay in the family after a child passes away. One of the most common things I see are provisions in a third-party trust that talk about paying money back to the state. No place in a third-party trust at all. It's confusing. Or they'll say things like, if the law changes and we have to pay back money to the state, this is who you need to notify. This is ridiculous, terribly confusing to a trustee. My trust have provisions in it that if the law changes, we can update the trust. If the law changes and I got to pay someone back, then we'll talk about paying someone back. We're not going to confuse anybody or make more legal fees or make things confusing. That is one of the most common mistakes I see. Another common mistake, and that is a mistake of law, by the way. Lawyers, that is a lawyer mistake. That's not a client mistake. You shouldn't know that as a client. That is a lawyer mistake. Third-party trusts do not have payback requirements in them. So that is a big, big mistake. So another mistake I see all the time is the language that we use in a third-party trust of how the money can be used. It should not say health, education, support, maintenance. When we use that language, that is typically used in a trust for a neurotypical child for distributions, health, education, support, and maintenance. The reason why we don't use that language in a special needs trust is that covers basic categories that are covered by benefits. Benefits are supposed to cover room, board, utilities, and then we have our medical assistance for our basic medical. So we don't want to do anything right off the bat that would say, oh, those monies are used instead of benefits. Everything in a special needs trust, we have to have the buzzword language, and you can't get around it. Your special needs trust has to say these monies are a supplement to and not a replacement for benefits. They are used to supplement and not supplant benefits. If you do not have that language, that is a lawyer mistake. Okay, you have to have that language. You can't dance around it. You have to have that language. It has to say that. The other issues in the trust that I see are not necessarily mistakes of law. They are more things of art that I think are important. Okay, and there is a difference. Okay, flexibility issues. In my opinion, you should be able to change who the trustees are throughout your lifetimes in these trusts, because who we think is right today could be very different than who is right tomorrow, 10 years down the line, 20 years down the line. So you have to maintain that flexibility. You should have really robust trustee provisions so that your trustees can appoint co-trustees if they need them. They can remove and replace them. We can have backups. We can have supports. We need this. We don't know how people are going to turn out. We need to be able to put in corporate fiduciaries if we need them. We don't know what our kids' lives are going to look like, what the future is going to look like. We just don't know. sitting here. We don't know what anybody's physical abilities are going to be, mental capacity is going to be. We need to be able to do that. Very, very important. And this is something that I can't really call it a mistake, but I kind of think it's a mistake, okay? Our trustees should, long after we are gone, have the ability to amend the trust to comply with changes in the law. Who thinks tax law is going to change? Who thinks Social Security law is going to change? Or Medicaid law is going to change, okay, over our lifetimes or our kids' lifetimes, okay? If I have to go to court to make changes in your documents, do you think it's cheap or expensive? If I have to get a judge's blessing every time to change something, it's expensive, okay? If I can amend it with the trustee and it's an amendment I can do in my office, it is much more cost effective. So I think every trust should give the trustee now or in the future the ability to amend the trust to comply with changes in the law to make sure your kid is never knocked out of benefits. Is it a mistake in the law if your documents don't have it? Maybe not technically. Should your lawyers think of it? I think so. Okay, I think so. So that should be in there. Then there are things as a parent that I think should be in there, like there should be check-in provisions that somebody's always having boots on the ground in there. I think we should have things built in to have people like Adam's company in there, like life care planners and care managers and all these other things in there. But these are the most common things I see, Susan.
Thank you, Randy. And this is just amazing what you as panelists are sharing with us, and doing another time check at 7:45 now. And Joanna, these questions deal with ABLE accounts. You know, like what is an ABLE account? When do you consider an ABLE account? How is it used in a disability planning? And also, what are the costs associated with it? That was one of the pre-submitted questions. So take it away, Joanna.
All right, I'm going to try to do this in a really short and concise way if I can. So our ABLE accounts, and I did see a question come up as far as like ABLE account or first party special needs trust. They are two totally different animals. ABLE accounts, which were not, it was an act that came out in 2014. It stands for Achieving a Better Life Experience. It allows our individuals who may be on benefits the opportunity to basically save and really fund a variety of different qualified related expenses without endangering these critical benefits that they're on. It does currently limit the eligibility to individuals with disabilities with the onset age of 26. Now, this has recently changed with the Secure Act 2.0. They've increased the age of onset to 46 because they saw a lot of veterans that were older, right, and became disabled during their time in war. And they realized, well, the vets also need this because disability can occur at any age, right? So, but this won't go into effect until 2026, unfortunately. I wish it were sooner. So the ABLE account, it can receive after-tax contributions from anyone. It can be the person who the account is set up for, or it can be a family member or a friend. The limitation on an annual basis is really tied to the gift tax laws, and currently in 2023, it's $17,000 per year. So you can contribute up to that amount each year with a total account balance of $100,000 without affecting government benefits. There are many states that have this program at this point. So if you're outside of Pennsylvania, see if your state has one, because there might be some tax deductions. In the state of Pennsylvania, we get the state income tax deduction for contributions into the account. If you haven't already done so, you can go to paable.org to get more information. But if you also wanted to compare different states' programs, you can go to, it's www.ablenrc.org. And so, you know, another benefit is that our individuals who are working, and they may have employer-sponsored plans, they can actually contribute more dollars to these accounts on an annual basis. Right now, that figure is $13,590. The account think of it like a 529. It's actually called 529A. The earnings in the account are tax deferred, and they can be withdrawn without taxes for qualified disability related expenses. Now, people say, well, what's that? I will tell you, this list from the ABLE program, it's very, very broad. It includes food, housing, rent, transportation, education. You know, I always say, keep your receipts, what it was spent on. I haven't seen them audit, but they can audit these accounts. These accounts do not, if they're passed on, there is no PA inheritance tax on these accounts. But when we really consider using these accounts is, let's just say your child is receiving income from SSI or SSDI, maybe they got a part-time job and they're really on that cusp of that $2,000 asset limit. We start shifting dollars over to the ABLE account, okay? Or for example, another thing is sometimes our children turn 18, like Randy said, and they might have some dollars in their name. So we're gonna add those dollars to the ABLE account if it makes sense, okay? And again, every situation is different. There's no cookie cutter, so we're gonna have a conversation about it. I always tell people, if you know you're going to have these expenses this year, put the money in, take the money out, you get the PA state income tax deduction. But this account does not supplant a special needs trust. It is a good supplement to a special needs trust. Remember, special needs trust, they can take any amount of money, right? That can go in there. ABLE account has limitations. The one I would say negative about the ABLE account, which is why I advise people you want to keep a lot of money in these accounts. Now, Pennsylvania can't seek Medicaid payback directly from the account, but if there was, if the beneficiary died or the owner of the account died and there was an estate open, then Pennsylvania could come in and seek recovery. I hope that, and as far as the cost, I know that there's fees. I don't know them off the top of my head, but if you're in the state of Pennsylvania, you can certainly go on paable.org and you can see what the different fees are to set up an account.
Thank you. That was definitely helpful for that answer or question. So we have about 10 minutes left. We're gonna do Adam's next question and then kind of end there. So Adam, what are some top concerns you hear from families when they come to you?
Yeah, absolutely. I think we've talked a lot about them today, so I'll be brief and talk about a few others that we haven't kind of come up with today. I think the first one which we kind of dabbled in a little bit, but I think rounds out a lot of what we talked about was parents oftentimes come to, I'm sure all three of the folks that are talking on the call today, and their biggest question is, who's going to replace me, right? What happens when I'm no longer here? And that's their biggest worry. And all of this effort that we're talking about today is really helping to plan for that, inevitability or that eventuality. And I think, one of the things that's really important, if you haven't gotten the kind of put it all together, by some of the discussion that we've had today, is that it's not going to be one person. Oftentimes we have folks that they want to know who that one person is that's going to replace them. And in my experience, and I'm sure in other folks' experience on the phone call here, it's not going to be, it's going to be a team approach. And so part of the planning process that we're talking through right now is building that team while you're alive. Building that team and putting them in place while you're alive and while you're able to have those conversations and make those decisions, so that when that comes, whether it's planned or unplanned or now or in a long time from now, that you do have that team in place so that your loved one is well cared for. Alongside that, we one of the things that breaks our heart and is one of the biggest challenges that we face when we have clients is to receive a call from a client when they're in crisis, and they haven't done any of this planning, right? Randy talked a little bit about the situation where someone ends up in the hospital and they don't have a power of attorney, and we have to go through all these emergency procedures to make medical decisions. It's not just that, right? If it could be a crisis of housing, right? And we don't have a place for someone to live, and now we have to find an emergency housing solution for someone with disabilities. And so we haven't done that, kind of gone through that planning process. It limits our options for solving that challenge. And so by going through this process, I think is really helpful. So that's a big concern that folks have. Two other ones that I'll just touch on really quickly, where my loved one's going to live, and it kind of corollary to that is what's the best state for them to live in. We get that question quite a bit. Pennsylvania, fortunately, is quite great from a benefits perspective. If you look at it across the country, we have a unique view of this, in that we work with clients in all 50 states. So we get to do benefits applications and help folks apply for benefits all across the country. And Pennsylvania tends to be pretty good when it comes to providing support and services to folks with disabilities. But we get questions about that quite a bit. Where is it the best to live? Folks that live in multiple states or have the opportunity to move, or have successor caregivers that live in other states. And so the short answer to that always is it depends on your unique circumstances. Everybody's kind of unique in their application of benefits and what they're entitled to. So and it can certainly change over time. But it's an important conversation to start is, where is my loved one going to live? Where is the individual with disability going to live? How is moving from one state to another going to affect their benefits? We've certainly seen families that call us after they've moved, and they've have to reapply for all these benefits and go back on wait lists. And so it's important to kind of plan for that ahead of time. And the last thing I'll mention, I know we have 1 minute left. I think one of the questions we get and concerns is when to start. When should I start this process, and when should I start planning? Whenever you're ready, the sooner the better, I think is probably the best message there. But certainly there's kind of inflection points in our lives and in our kids' lives that makes sense. And we call those life transition moments. So the transition to adulthood, the transition out of public school, transitions to independence, parents retiring, parents aging, those kind of natural transition points that affect all of us, whether we have a disability or not, are really good times to start having this conversation and start this planning process. But certainly if you're like me, I started planning for my kids' college the minute they were born. And so, if you want to start planning early, there's nothing wrong with that. So, certainly reach out to any of us when you're ready to start the process. So.
Thank you, Adam. I know, Kodi, I don't know if you're going to stop the recording, but I just wanted to say that since we only have like 5 minutes left, I know there's a lot of questions. Would it be okay if we send you guys the questions and we can get the answers to, when we send out
one of the follow-ups?
Yeah, we can send them a follow-up. The one thing I do want to say is, I know, Randy, you talked a lot about this, and as advocates, we always tell our parents, even kids with disabilities at 18, parents think they're still the guardian. If that's number one in my head, is to teach parents that at 18, before they turn 18, start the process, because parents don't understand that. What do you mean? My child has a disability. How can I said it doesn't matter. So that's the one thing I know. I did that for my oldest daughter, power of attorney. And I love that you said, Randy, even for typical kids, you should have power of attorney, because if they get into an accident. So that's something I know as advocates, we're always striving to let them know. But I just, we have less than 4 minutes. I don't know if there's anything the three of you want to say quickly to end the tonight's, anything that maybe one thing that you could say to the parents. Remember this. I know you guys you did such an awesome job, such great information. My head is spinning, like you said, but great information. So I just thought if you guys wanted to just one thing to take away tonight, and then we'll get the answers we have a lot of questions, and I appreciate all the questions coming in. So I don't know, Randy, do you have anything you want to share? One more thing that the family should remember?
Sure. Don't be intimidated by the words estate planning. If you have a house, you have an estate. If you have a car, you have an estate. It's not fancy. You don't have to be rich. I mean, if you're rich, great. We love that. It's more fun. It's fun to do things, right? But if you're not rich, there's ways to leverage things and leverage money. The name of the game is leverage. So don't be intimidated if we need to find ways to get money to that trust, because there's ways to do it. There's ways to do that and leverage benefits to do that with our kids as well. So just don't be intimidated, jump in, grab the reins. There's experts to help you, and it's one step at a time.
I was just going to say, we're all real people. I don't think any of us are scary, and we all offer our complimentary meetings to get introduced to you, your family. You know, we don't charge for that. So there should, I often wonder why parents, outside of the fact that they're juggling a million things, hesitate to reach out to, whether it's a care management agency or an attorney or someone like myself. And I think it's scary. But no plan can also be really devastating. So feel free to reach out. You'll have all of our contact information after this meeting. And I just want to say that without this being really a comprehensive approach to this type of planning, your planning is not done. You can't just get the legal documents and think that that's it. There needs to be assets to go into those legal documents, the special needs trust. And then there needs to be a quality of life plan, like Adam mentioned, so that you can actually implement that care plan in the future. So it's not until all of these different areas are really kind of checked off that the plan is always going to be evolving. It's going to evolve over time. So making sure that our plans are flexible is really important.
Yeah, Joanna kind of hit what I was going to mention. It's important to start, but it's never the end of the planning process. And I think that's one thing to remember is, start, get your documents in order, but then be flexible, and recognize that all of our lives change over time, and you'll have to adjust and adapt as your kids grow up, as you grow old, and it's important to ensure that you have a place to start. There was one quick question about whether we work collaboratively. Yes, absolutely, always. And if you ever find someone that's not working collaboratively, call us, because that's not the right way to do it in our minds. So certainly it's important for all of your professionals that you're working with to work collaboratively, and we love to do that. We like to stay in our lane, and know what we know, but it's important to rely on others that have that expertise that we don't have. So it's great working collaboratively to solve challenges with you guys. So
thank you all three for this great presentation. Definitely learned a lot. I think all our attendees obviously have a lot of follow-up questions as well, so we'll forward those over to you, but thanks again.